Welcome to Counterpoint. I'm Tanya Granick-Allen. Families have been impacted in so many different ways during this time of COVID, between lockdowns keeping parents and children in, to switching back and forth from online to in-class learning, to homeschool co-ops being canceled, to many extracurricular activities being shelved. Suffice to say that COVID hasn't been easy on families. And now, with vaccine mandates, it seems families are having to navigate even more, and in some cases, sacrifice even more when making these hard decisions. Recently, 2 Ontario Superior Court justices waded into the whole vaccine mandate discussion when it came to custody of children. One justice ruled that an Ottawa mom is banned from telling her 14-year-old son not to get the COVID-19 vaccines and prohibited by court order from showing him online information that calls into question the safety or efficacy of vaccines. Furthermore, dealing with the custody of triplets aged 14 in another case, that each of these triplets get to decide about that vaccine themselves, and that their mother, who has custody of one of the boys who is hesitant, must also allow the same. So what will the impact be on families with these 2 recent court decisions? How might they impact your family? Well, joining me later on will be Peter Stock to offer his commentary. But now to help us unpack all the legal aspects is Jared Teitel, family lawyer with Normandin Chris Law Firm. Jared, thank you so much for joining me today. I appreciate your time.
Thank you, Tanya. It's a pleasure to be here.
So when I read these headlines and look at some of these court rulings, I'm scratching my head trying to make sense of it all, because in some ways, vaccines have always been with us. And now with the COVID jab, it seems we're in a whole new sphere. Can you help us understand what's going on with family law these days?
Certainly. Well, the advent of the pandemic and the COVID era has certainly brought about quite a lot of discussions and changes in very interesting cases from the courts. We've seen the COVID issues crop up, and what I'm going to say 3 large buckets of issues for families. The first being at the start of the pandemic, what happens to parenting schedules? For example, if one parent feels the other parent is not sufficiently taking precautions against the pandemic, what can a parent do in terms of restricting or changing the access? The second, we saw quite a bit about earlier in the pandemic, earlier this year, when schools started to reopen in person, in terms of what is the decision in terms of whether the children are to go back in person or whether they can continue to attend online. And then the current hot button issue is, of course, the vaccine, since public health made the recommendation for children ages 12 to 17 in terms of whether what the courts can do and what the courts are ordering in terms of vaccinating children.
Okay.
So
go ahead.
I was just going to say, on the 2 cases you mentioned, of course, on the vaccine issue, currently what we're seeing from both decisions is a general presumption in favor of the vaccine.
Right.
Subject to any specific medical reason why the vaccine should not be ordered. But courts are taking a hard look at that issue and being very clear that the presumption is in favor of the vaccine, subject to specific medical evidence to the contrary.
Okay, so before we delve into these 2 cases, because they're very fascinating, as a laywoman, I'm not an attorney, looking back, standing on the outside, I might ask myself, well, why would a judge rule on the merits of a vaccine or on this issue at all? They're not a scientist, they're not a doctor. How can they make that kind of decision?
Well, the first point we need to understand is that family courts have jurisdiction over a specific set of families. We're talking about separated families, so families that are no longer intact, and more specifically, where the 2 separated parents are unable to reach a consensus with respect to what decision should be made for their specific child. So family courts are not making orders for all families.
Okay.
And then that second piece comes down to the focus for any parenting decision, whether it's a vaccine decision, a school decision. The ultimate test is with respect to what is in the child's best interests, which of course is a loaded question. But the Supreme Court has said on many times over that parental rights and preferences don't play a role unless they're necessary to determine those best interests.
Wow. So if you are not engaged with family courts, if you're not separated, divorced with children and custody issues, then this really doesn't apply to you. But if you do have custody arrangements with another parent of the child, then you may need to listen to what we're going to discuss. We're going to go to commercial break in just a few moments, but when we come back, we're going to talk about what's in these two specific court rulings that may impact you and your family. We'll be right back. Welcome back. We're discussing two recent family court decisions that may impact your family or maybe a family you know. And joining me again is Jared Teitel, family lawyer with Normandin Chris firm here in Toronto. Jared, two very interesting cases, similar outcomes if you were to ask me. What do you think the takeaway is from these two cases?
So I think the big takeaway, so in both cases, there was one parent in favor and one parent not in favor of the vaccine. And in both decisions, the court really favored what's best for this child, but more so let the child make the informed decision. Because under the Healthcare Consent Act, there's no age requisite to be able to consent. It's the test under the Healthcare Act is whether the minor is considered mature. So in both decisions, it wasn't compelling or ordering the parents to vaccinate the child. It was enabling the parents to be able to facilitate the child getting his or her own vaccine.
Okay, and that's a very good point to make. And many families may not be aware of this, but at least in Ontario, and you could correct me if I'm wrong if this is similar in other jurisdictions in this country, but in Ontario, really it comes down to capacity to consent, right? A child, if they show capacity to consent, then they can consent to their own medical treatments. There's no prerequisite age. It's not defined as to what age. Is that correct?
That is correct. The healthcare consent specifically uses the term mature minor, but that's a very subjective circumstantial test. But the rationale behind it is, as you just say, to not set a specific age and to give children more authority and personal autonomy in their healthcare.
Okay, so tell us what happened in these two cases.
So in both cases, one parent was in favor and one parent wasn't in favor. But the decision out of Ottawa, the child was 14 years old, and the child initially wanted to be vaccinated. The child had an appointment with their medical doctor and had a conversation there. And then the details we have from the decision is that the child's mother did not want the child to receive the vaccine and was having a lot of conversations with the child, sending a lot of articles to the child. And it reached the point where the children's lawyer was appointed to advocate and to present the child's views and preferences in court. And the child's position actually changed one day before the hearing from wanting the vaccine to not wanting the vaccine. And the judge picked up on the child's views were not the child's own. They weren't independent. The court found the mother was influencing the child's views based on the child being able to suddenly having a change of mind, but not being able to justify or explain why he suddenly didn't want the vaccine. So the court actually went and made an order to enable the father to have the child vaccinated, but specifically made an order preventing the mother from speaking to the child about the vaccine issue. It goes further than that. The mother can't send articles, can't send anything on social media or text or have these conversations. But the thrust of the decision was to enable the child to make an informed decision about the vaccine, free from any noise from either parent.
But isn't that the role of the parent when you're helping your child navigate issues in life, to make these informed decisions, to provide them some information, maybe balanced, maybe one-sided, I don't know, but what's could be so criminal about that?
So that's part of the big issue here. And it comes down to the ultimate test in all these decisions is what's best for this child.
Right.
And our courts have already taken what's called judicial notice, which is a fancy term for a court accepting certain facts at face value without a party having to specifically prove them. And by that, I'm referring to the newsletters and releases from Public Health Canada and Ontario with respect to the recommendations for vaccines and their efficacy and the validity of such vaccines. But what I find quite fascinating is we're seeing the courts put the child in the driver's seat about that decision to be able to make his or her own informed decision.
Okay. And now with this other case, we had a case of 14-year-old boy, but they're triplets, 3 boys, 14 years of age. What happened there?
So that was another interesting one. We have triplets, 14. One was in virtual school, 2 were in in-person school. The decision does not say why. That decision's interesting because the two children from the onset wanted to receive their vaccine.
And they lived with the father. I think
I believe so.
Yeah,
that's
the two who were in virtual school lived with the father, and the one in-person class lived with the mother.
That's correct. So the two with the father wanted to receive their vaccine. They were united in that viewpoint, but they couldn't because their mother had their health card, and the mother wasn't providing the health card to the children, so the children weren't able to get it. So that case, there wasn't a discussion about undue influence or the independence of the child's views. That was accepted, at least from how we read the decision. So for Justice Charney, in that case, it came down to crafting an order to ensure that father had the health cards to give to the children so the children could go get their vaccine.
Okay.
But in both cases, just to summarize, in both cases, we're seeing the court place the child in the driver's seat in terms of making that decision.
Jared, some families who have split, one parent is awarded sole custody, sole decision-making authority for the healthcare, schooling decisions, that kind of thing over their child or children. In that kind of circumstance, could it be the case that potentially the non-custodial parent, the parent who has zero decision-making authority over that child, could petition the court and say, you know what, I don't like that the custodial parent is not allowing the child to get the vaccine. I'd like to petition that I now get that decision-making authority.
So the short answer is, of course, it depends on the specific circumstance. And I will say we haven't seen a specific case come out dealing specifically with that issue in the context of the COVID vaccine. The cases that we were discussing earlier, the parents had joint custody or shared decision-making. But let's put it this way. In a situation where a parent has exercised decision-making in such a way as to not follow routine medical advice, especially advice universally given for most children in Ontario, the court can review the reasonableness of the parent's decision-making process and almost engage in a review of what the parent considers and relies upon to arrive at that decision.
Okay, and this is another question that just came to mind. Again, I know you made it very clear that the Superior Court simply deals with separated families where there's custody arrangements and legally straightened out custody arrangements. What if you have a non-separated family, a family that's intact, for lack of a better word, and there are no custody issues? But what if that family as a unit chooses not to proceed with the COVID vaccines as we have seen? Can somebody, a CAS worker, a child services worker, petition the court that maybe the courts need to intervene there?
So theoretically, I mean, we've definitely seen that issue come up with child protection organizations in the context of, for example, a family that was practicing Jehovah's Witnesses, and the issue of blood transfusions came out, where the Child Protection Agency came forward to seek an order placing the child under protection to be able to make the decision for the child. This was dealing with a very minor, younger child. To receive that treatment. And the Supreme Court of Canada said no, and the application was rejected. So we do have a precedent in Canada with respect to the courts respecting intact families, for lack of a better term, respecting their decision to refuse or consent to specific treatments for certain medical conditions. What we haven't yet seen is that issue play out specifically in the context of the COVID-19 vaccine. Again, right now we're seeing these cases being dealt with for children ages 12 to 17, where the views and preferences of the child are much more easily ascertainable than, let's say, for example, a 3-year-old or a 4-year-old.
Right.
So that's why the focus of the current decisions under COVID has been to enable the child to make the informed decision. But obviously that'll be less of a focus when, if and when the recommendation comes for younger children, where it is more of a decision to be made between the two parents.
Okay, we'll have to keep our eye on this. Thank you so much, Jared, for your time today.
Thank you. It was a pleasure.
Okay, very good information we received there. However, joining me now to unpack some of the more political and parental rights aspect of these concerns is Peter Stock, president of Homeschool Legal Defense Association here in Canada. Peter, thank you so much for joining me today.
My pleasure.
So we just heard from a lawyer who really dissected what these two decisions mean for families who are in courts dealing with custody arrangements. And, reading one of the decisions myself, it was quite interesting. I don't read that many decisions, but reading it was very fascinating. The whole one of the things that kept jumping out at me is, well, what is the role of parents? Here we see a lot of responsibility being placed on the children to make their own healthcare matters. Where are the parents factoring in all this?
Yeah, I read the decision too, and I actually think that was a serious mistake on the judge's part. When we think about these COVID vaccinations or shots, they're not really vaccinations. We're talking about something that could have very serious long-term health impacts on these kids, and yet at the same time, are these shots really necessary? And I think that's a question that a lot of parents are asking and coming to some very different conclusions about. So when you say, oh, the kids can make up their own mind on this, I don't think so. I think kids have very short-term outlooks. They say, if this means I can't play hockey, basketball, go to my friend's birthday party, then yeah, I'll take the shot. But do they have any idea what it means to get myocarditis or pericarditis? A lot of adults don't even know what that means. So to say a child can give informed consent to this kind of treatment, I think is irresponsible.
No, you bring up a very good point because you're right. Children usually just look at the short term. Here, I'll give you candy if you go clean your room. Oh yeah, I'll do it right away, Mom. But they don't think long term, well, what kind of precedent am I setting here? I want to dive more into this just when we return from this commercial break in a moment. Welcome back. We're discussing COVID-19 jab, the vaccine, and how that may impact you as your family, especially if you have a custody arrangement with the courts. Peter, before the break, we were talking about how parents really don't factor into this decision-making. And if a mature minor, as the courts say, she can show capacity to consent, then they can consent to whatever medical treatment. There's no prescribed age. But there's sometimes, a 5-year-old consenting to something. I mean, we know that the government is looking to approve the vaccine from 5 to 11-year-olds. Can a 5-year-old consent to medical treatment, truly?
I don't think so. And as we were saying before the break, I'm not even sure that a lot of parents are giving informed consent. There's an incredible amount of coercion happening on the part of governments right now. If these shots were so great, why do we need to convince anybody, honestly? I think most parents look at vaccination and say, yeah, I'm all for vaccination. I'm for vaccination for mumps and measles and a whole bunch of other diseases. But there's a lot of concern about these particular shots. First of all, they're not vaccines. They're experimental treatments. They haven't been proven yet. We don't know the long-term health consequences. To say that we're going to take a risk with the health of our nation's children, I think there are a fair number of parents who have a problem with that.
Well, one aspect of one of the court decisions with respect to the Ottawa mom, because there are two cases, one with triplets and one with the Ottawa mom who had just a 14-year-old son, one son, she was banned by court order, prohibited by court order from showing him online information that may call into question the safety or efficacy from the vaccines. So that really surprised me. And I mentioned this with the attorney we had on a few segments ago. Isn't that the role of parents, to help guide their children? If you cannot communicate effectively, or if you're barred from communication with your child in certain areas, how is that parenting? Isn't that not doing your job as a parent?
Yeah, I would say it interferes deeply with that. And it also violates, again, the principle of informed consent. How can you be informed if you don't hear various points of view on an issue, have access to, and you know what, we're not talking about conspiracy sites here. There are dozens of studies on these topics that show either the efficacy or lack of efficacy of these shots, the health consequences potentially of these shots, some of which are listed on the label. But what I find interesting is despite the fact that there are clear concerns, they're being ignored in the courts, and that's a problem. Look at who's saying no to these shots. Some of the groups in society that are saying no to these shots are among the highest educated people in our society. There are healthcare workers. Those are the groups of people that have the greatest concern about these shots. So it's not some conspiracy theory. There is a lot of solid scientific information, and everybody, not just kids, but everybody should have the right to access that and determine for themselves, hopefully in consultation with their doctor or healthcare provider.
But some might argue, or someone might suggest that, hey, you know what? But if there's this young person and they might be impacted by COVID in some way, they may not be going to in school learning, or they may not be able to access their extracurriculars because for whatever reason, this is the mandate that the government has given. That's not good for their mental health either. So should a parent have the authority to withhold that access to that vaccine from the child, knowing that they could have other side effects by not engaging in some activities they enjoy?
Yeah, so it's a question of the short term versus the long term again. And I think that parents have to be trusted to determine what is in the long term interest of their children. Looking simply to the short term is going to lead to serious problems for a number of people.
Right. Well, I guess we're going to have to continue looking onto that. Do you have anything else that concerns you? We have about 40 seconds left. Anything else that concerns you with these decisions?
Yeah. Well, as somebody who leads a homeschooling organization, this is the sort of thing that's forcing some families to think about homeschooling. We're in a position where we say we don't want people to be forced into homeschooling. We want them to choose that of their own accord. But this is the direction that governments are forcing families, parents to go, is to consider options to the mainstream, so-called.
So it sounds like less parental choice, not more. Listen, we'll have to keep an eye on this issue, and we'll have you back on again, Peter. Thank you so much.
Thanks, Tanya.
Children's rights versus parental rights. How are children's rights best protected? I would argue they're best protected when parental rights are protected. We'll have to see what the future holds as we look for potentially future court decisions coming down the pipe. For Counterpoint, I'm Tanya Granick-Allen.